All right, we're on the record in cause number 2410155-21 by Zoom, State versus Christopher Britton, present by Zoom. Ms. Anderson's representing the state by Zoom. Marcella, the court's probation officer, is on by Zoom. Mr. Clifton Roberson's on by Zoom. The defendant, Christopher Britton's on by Zoom. This is on a motion to adjudicate guilt. You want to waive the reading and presentation of the motion to adjudicate guilt and all the other formalities, Mr. Roberson?
Judge, we waive the formal reading of the motion to adjudicate guilt. He knows what the allegations are. His name is correctly set forth in the motion. He's going to enter a plea of truth to all allegations, Your Honor.
All right, Mr. Britton, raise your right hand. I have to swear you in. Do you solemnly swear your testimony will be the truth, the whole truth, and nothing but the truth, and that all these plea documents signed and then which show to be sworn to by you are being sworn to by you now under oath, freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Britton, if you're going over the state's motion to adjudicate guilt with Mr. Roberson, you're a court-appointed attorney, so you understand the allegations being made by the state against you for violations of your deferred adjudicated probation on an original criminal charge of violation of a protective order.
Yes, sir.
You understand if you plead true to those violations or the court finds those violations to be true, the court would grant the state's motion to adjudicate, go back, find you guilty of the offense charged in the indictment. Then you could receive up to a maximum of 10 years in TDC, fine of up to $10,000. You understand all that?
Yes, sir.
All right, if you look at the written plea admonishments and stipulations of evidence, which will be going up on the screen, you'll see where it is signed down at the bottom. There's like 4 admonishments at the top, 1, 2, 3, and 4. Those are called admonishments. They're just explanations to you. Do you understand all those?
Yes, sir.
Coming down to the next paragraph, here's what you say. Understanding the admonishments and the allegations alleged against you for violations of your motion to adjudicate, of course, are set out in that document. And then you say, acknowledging the foregoing, you state you fully understand, have read the foregoing admonishments, that's 1 through 4, as well as the allegations against you set out in the state's motion to adjudicate. Then you say, understanding the admonishments and allegations, you make the following free, knowing, intelligent, and voluntary stipulations of evidence. 1, obviously, they're the individual on deferred adjudicated probation in this case from this court. Then you say under 2 that the allegations as set out in all the paragraphs of the state's motion to adjudicate are true. Then you, with Mr. Roberson present, are entering pleas of truth to all the allegations in the state's motion to adjudicate. All those allegations allege violations of your deferred adjudicated probation terms. Do you understand all that?
Yes, sir.
Is that correct that you are stipulating and entering pleas of truth to all those alleged violations?
Yes, sir.
All right, are you stipulating and into those pleas of true, understanding the results of those pleas of true would be obviously I will find the allegations true because you're pleading true. I'll grant the state's motion to adjudicate, just a legal word, meaning I'll go back and find you guilty of the offense charged in the indictment, and then you can receive up to the maximum because you were on deferred. Do you understand all that?
Yes, sir.
All right, Ms. Anderson, you want to offer state's file?
I do at this time, Your Honor.
No objection, Your Honor.
No objection. State's file, the written plea admonishments, stipulations of evidence is admitted into evidence. The court having admitted into evidence, state's file, the written plea admonishes stipulations of evidence as set out in that document. The court does find that the allegations in all the paragraphs of the state's motion to adjudicate are true based on the defendant's stipulated and entered pleas of true. The court does grant the state's motion to adjudicate. The court goes back and finds the defendant guilty of the offense of violation of a protective order, 3rd-degree felony, maximum up to 10 years in TDC, fine of not to $10,000. You have a recommendation, Ms. Anderson?
Yes, Your Honor. The recommendation is 4 years confinement in the institutional division.
Agreed, Mr. Roberson?
That is correct, Your Honor. We were requesting that the court follow the recommendation.
All right, the court will follow the recommendation. The court having granted the state's motion to adjudicate guilt, the court does find the defendant guilty of the offense of violation of a protective order. Third-degree felony is alleged in the indictment, follows the agreement on the motion to adjudicate, assessing the sentence at 4 years in the Texas Department of Corrections Institutional Division. That sentence is assessed with credit for time served. Is there any restitution due?
Your Honor, there is no restitution due, but the state would ask that you would continue the no contact order with the victim, Adrian Simpson, for the duration of his confinement and parole.
All right, the court finds no restitution due. However, a term of this sentence of 4 years in the Texas Department of Corrections Institutional Division, one of the terms of the sentence, which will be reflected in the judgment, is that the defendant, Christopher Britton, is to have no contact whatsoever with the alleged victim in this case. That would be no contact in person. He cannot go within 1,000 feet where she's located. He cannot contact her by any means, such as cell phone or any of these electronic devices, Facebook or Twitter or any of those others. No contact with the victim. Anything else?
Not from the state, Your Honor.
Anything else, Mr. Robertson?
No, Your Honor, and I did explain to my client about that condition. And I did explain to him that if it was a situation, if they were to get married, then they have to let the parole division know about that, Your Honor.
That's exactly right. The court in this case then, having received and accepted the defendant's stipulated pleas of true in the written plea admonishments, stipulations of evidence, the court having found the allegations in the state's motion to adjudicate to be true, the court having granted the state's motion to adjudicate, the court finding the defendant guilty of the third-degree felony offense of violation of protective order, following the agreement, assessing the sentence and formally pronouncing sentence at 4 years in the Texas Department of Corrections Institutional Division, pronounced with credit for time served, and in addition, a specific condition to be reflected on the judgment and in the terms that the defendant can have no contact whatsoever in person, presence, or any electronic device, cell phone, Twitter, or any of the others with the victim in the case. That would be a term of the sentence of 4 years in TDC with credit for time served. All right, if there's nothing further, only other question, Mr. Britton, are you satisfied with the court-appointed representation of your attorney, Mr. Clifton Robertson?
Yes, sir.
All right, Mr. Britton, you're continuing to custody of the sheriff. You can be transported to a unit of the Texas Department of Corrections Institutional Division, serve a 4-year sentence assessed by the court with credit for time served and with a no contact order as it relates to the victim in the indictment. If there's nothing further, counsel, we're in a recess.
Okay, you can let them know that we need Carew next.
Ruth.
Yes, Danny
Yes, ma'am.
Carew.
All right.
This is going to be Mr. Gerald's case, Judge Skeen.
Good.
I'll just stay on for ornamentation.
Why don't you stay on for orientation? There's probably another one behind it, I guess.
Yes, sir.
All right, this is cause number 2410118-21 State versus Danny Carew. He is Danny Carew is present by Zoom before the court from the North Jail. His attorney, Mr. Robertson, is present by Zoom. Ms. Anderson is present by Zoom. Of course, probation officer is present by Zoom. I'm not seeing Mr. Gerald.
I think he's in the waiting room, Your Honor.
I can see all y'all, Judge, and I'm
I got you. Brian.
there we go.
I got Mr. Gerald on now. All right, this is on an indictment 2410118-21 charging manufacture delivery of a controlled substance as alleged in the indictment. The indictment has 2 enhancement paragraphs in it, the second and third paragraph. Mr. Carew, I'm going to read each one of those paragraphs to you, and I'm going to ask you whether or not your plea is true or not true. If you enter a plea of true to the second and third paragraph of the indictment, which allege prior convictions for felonies, delivery of a controlled substance, and manufacture, delivery of a controlled substance. If you plead true to both of those, it will enhance the floor, the bottom of your sentencing range will go up to no less than 25 years, and the maximum will be 99 years of life in the Texas Department of Corrections habitual sentencing range. Do you understand that?
You're on mute, Danny.
I'm not sure you can hear me, Mr. Robertson.
He can hear Judge. He's on mute. Danny's
Oh.
on mute.
Okay, I can't hear him, obviously.
They turned it off, Your Honor.
Okay.
Yes, sir. Can you hear me now?
Yes, I can, Mr. Carew. I can hear you now. Could you hear everything I
Yes,
just
sir.
said? Okay.
Yes, sir.
So you understand right now your full range of sentencing on this indictment charge of manufactured delivery of a controlled substance has been enhanced up to a habitual sentencing range, not less than 25 and more than 99 years of life as a result of your pleas of true to the allegations of prior felony convictions in the second and third paragraphs. You understand that?
Yes, sir.
All right, you've got an agreed punishment recommendation, which is going to be going up on the screen where you can see it. It's signed by your attorney, Mr. Robertson. It's signed by Mr. Brian Giral. And over there on the line above where it says defendant, there's a signature I can easily read, signed Danny Carew. Is that your signature?
Yes, sir.
That signature is going to be on all these plea documents, and I'll need to be sure and get you sworn to them. But did you go over all these plea documents with Mr. Giral, state's attorney? So I'm sorry, did you go over all these plea documents with Mr. Robertson so you understand each one of these plea documents? And I'm going to identify them for the record.
Yes, sir.
First of all, you've got your plea agreement. It's up on the screen. If you enter plea, well, let me get your pleas of true in. I'm going to read this second and third paragraph to you, ask you whether or not your plea is true or not true. You've actually stipulated to both of those in the stipulation of evidence that is in the case, but to be sure, I'm going to read them to you. It's further presented prior to the commission of charged offense here and after style the primary offense on the 21st day of June 2005 and cause number 241027205 in the 241st District Court of Smith County, Texas. It's alleged you were finally convicted of the felony offense of delivery of a controlled substance, analog 4 grams or more, but less than 200 grams. Are those allegations true or not true?
Yes, sir. True.
Moving to the second paragraph, it's further presented prior to the commission of the primary offense that after the conviction in cause number 241027202 was final, it's alleged you committed the felony offense of manufactured delivery of controlled substance as alleged in this paragraph. More than 4 grams, but less than 200 grams, and you were finally convicted on the 14th day of November 2013 in cause number 114-1426-13 in the 114th District Court of Smith County, Texas. Are those allegations true or not true?
True.
Are you entering your pleas to the allegations in both these paragraphs, charging prior convictions freely, intelligently, knowingly, and voluntarily?
Yes,
Are
sir.
you, okay, no one's threatening you anyway or promised you anything to get you to
No,
plead
sir.
true. All right, court receives and accepts your plea of true, finds as true the allegations in the second and third paragraph of the indictment alleging prior felony convictions, which now sets the full range of sentencing as a habitual as set out in the plea papers, not less than 25 years, no more than 99 years of life in the Texas Department of Corrections Institutional Division. Of course, obviously, Mr. Carew, as you can see, and as you know from the agreed punishment recommendation, if you enter a plea of guilty to the offense charged in the first paragraph, manufactured delivery of controlled substances charged in the first paragraph, Mr. Giral, state's attorney, is going to recommend to the court, and I'm going to follow it on your plea of guilty, that your sentence be assessed at 32 years in the Texas Department of Corrections Institutional Division. Also, as agreed, time credit would be assessed for you, time credit for already served from 11/27 or 29/1920 to the present. Is that your plea agreement?
Yes, sir.
And you understand also, of course, there'll be a lab fee assessed to DPS of $180. You understand that?
Yes, sir.
Also, down there under 6, as you can see on down a little bit, pursuant to Penal Code Order 1245, I am taking into consideration two indictments, 241011921 for
Hey,
possession of.
I'm on Zoom court. Let me call you back. Can you give me about 30 minutes?
You want that in the record, Mr. Robertson? Okay, I guess you don't. Pursuant to Article 1245, the court will consider the following unadjudicated offenses, Mr. Carew. 241011921 for possession of controlled substance, 2410120-21 for manufacture delivery of a controlled substance. I'm taking those two offenses into consideration under Article 1245 in the assessment of the 32-year sentence in the Texas Department of Corrections Institutional Division with credit for time served, which means Mr. Giral will dismiss those two indictments. Do you understand all that, Mr. Crowe?
Yes, sir.
Is that your plea agreement?
Yes, sir.
Is that it, Mr. Giral? Is
It is, Your Honor.
that correct, Mr. Robeson?
That's correct, Your Honor.
All right, now all these plea documents I'm going to identify now are signed and sworn to Mr. Caruth. They're going to go up on the screens, but after I identify them, I want you to be sure you understand all of them. We've been over your plea agreement, 32 years in TDC with credit for time served, with the court taking those other two indictments into consideration, which means Mr. Giral will dismiss those, and you've got a lab fee to DPS in the amount of $180. That is your plea agreement that I'm going to follow. The acknowledgement of admonishments, that gives you that full range of sentencing. We've already been over a couple of times, not less than 25 to more than 99 years. TDC, that's habitual. Your sentence will be set by the court at 32 years with credit for time served. You see on those admonishments, there's actually a total of 7 of them. Then it's signed Danny Carew and Mr. Robertson below 7. Do you understand all 7 admonishments?
Yes, sir.
Then the next document's obvious waiver of trial by jury. It does what it says. You tell the jury, you tell the court you wish to waive and give up your right to a jury trial. You say you knowingly, intentionally waive, meaning give up your right to a jury trial. Ask the court to just follow the plea agreement and assess the sentence on your plea of guilty. Is that correct?
Yes, sir.
You signed and sworn to a waiver of confrontation with witnesses and an agreement to stipulate. The agreement to stipulate is a stipulation of evidence states to, signed and sworn to by you. Now, you understand the stipulation of evidence signed and sworn to by you. That is a written judicial confession by you to all the allegations and the charge in the indictment, including the prior offenses. Do you understand that?
Yes, sir.
And you, of course, already signed and sworn to this stipulation of evidence freely, intelligently, knowingly, and voluntarily, correct?
Yes, sir. Yes, sir.
Great. There's an agreement to stipulate testimony. Also, I'm sure you understand there's a document you've waived and given up your right to appeal, and you waived and given up your right to file a motion for new trial. Do you understand that?
Yes, sir.
All right. Understanding all the allegations, the charge in the indictment, and your plea agreement and all your plea papers, do you still wish to go forward on your plea of guilty to the indictment without a jury?
Yes, sir.
All right, hang on just a second, Mr. Carew. I've got to take a quick break. I'll be right back.
All right.
I got some papers I got to pick up. All right, we're back on the record by Zoom, 2410118-21, State versus Danny Carew, present for the court by Zoom with his attorney, State's Counsel, Mr. Rawls, present. All right, now I'm going to go through and ask you to pick up right where we left off. And what I'm going to do is ask you some questions. Mr. Carew, they're about as straightforward as you can get, but if I ask anything, not sure you understand, be sure and tell me, okay?
Yes, sir.
All right, do you still wish to go forward on your plea of guilty to the indictment without a jury and ask the court to follow the plea agreement?
Yes, sir.
All right, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, or toxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case and everything you're doing in court today and all these plea documents I've identified that are signed or signed and sworn to by you and signed by your attorney, Mr. Roberson? Have you been over all those documents with Mr. Roberson?
Yes, sir.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Mr. Durrell?
No, Your Honor.
All right, court notes State's counsel has signed his consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury and all the other waivers in the case signed or sworn to by the defendant, signed by his attorney. All right, now you have gone over, Mr. Carew, in this case, you have gone over with Mr. Roberson the allegations in the indictment, the charge in the indictment, the full range of sentencing. So you do understand all the allegations and the charge in the indictment. Is that correct against you?
Yes, sir.
You understand the full range of sentencing and all your plea papers, plea documents you've signed or sworn to that your attorney and Mr. Rawl have signed that we've been over. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 241-0118-21, what is your plea today to the indictment charging you with manufacture or delivery of a controlled substance enhanced up to a habitual sentencing range not less than 25 years, no more than 99 years or life?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way, promised you anything, coerced you, or made you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment today as a result of any type of delusion you have in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty, Mr. Carew, to the offense charged in the indictment enhanced to a habitual range. What do you have, Mr. Giroux?
Your Honor, we offer states 1, the signed stipulations and waivers, states 2, the stipulation of evidence with a true and correct copy of the indictment, and states 3, the 3914 compliance forms.
No objections, Your Honor.
With no objection, court approves, admits into evidence, State Exhibit 1, all the plea documents, states 2, the signed and sworn to stipulation of evidence, which is the written judicial confession under oath by the defendant to all the allegations and the charge in the indictment, including enhancement paragraphs, and states 3, discover compliance from the states admitted into evidence without objection. The court does find the defendant's waiver of his rights, execution of all the other documents in the case were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. Further, the court does find the evidence submitted into the record by the court is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. Therefore, the court does find the defendant guilty of the offense alleged in the state's indictment and will move to sentencing.
Your Honor, we'll bring the digital copy of the written discovery down to the court's office. It would be states 4.
Any
No
objection?
objection, Your Honor.
With no objection, states 4, all the written discovery, which is on disk, we file with the court by Mr. Giroux. Anything else, Mr. Roberson?
No, Your Honor.
All right, the court of the case then, based upon the defendant's plea of guilt to the offense alleged against him by the state in its indictment and the evidence presented and admitted into the record by the court does find the evidence in the record is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. The court does first of all find the defendant guilty of the offense alleged against him by the state in its indictment, and the court follows the plea agreement, the recommendation of the state, sets the sentence in the case at 32 years confinement in the Texas Department of Corrections Institutional Division, no fines assessed, court costs ordered paid. Restitution is ordered DPS for the lab fee in the amount of $180. Any legal reason for formal sentencing, Mr. Robeson?
No legal reason, Your Honor.
99, the court formally pronounced the sentence. The court does find the defendant guilty of the offense alleged against him by the state in its indictment, follows the plea agreement, the recommendation of the state, assesses the sentence and agreed to by the state and agreed to by the defendant and his counsel. The court following that plea agreement assesses the sentence at 32 years in the Texas Department of Corrections Institutional Division. The 32-year sentence is assessed with credit for time served. Waiver of appeal filed by the defendant, signed by his attorney, is approved. And waiver of right to file a motion for new trial is also approved. Sentence is formally pronounced by the court. Now, Mr. Carew, you don't understand right there at the last, what I've gone over is the fact that you have filed with the court, signed by your attorney and you, a waiver of appeal, giving up your right to appeal in this case. You understand that?
Yes, sir.
You've also filed, signed by you and Mr. Robeson, a waiver of your right to file a motion for new trial, giving up that right also as part of your plea agreement. You understand all that?
Yes, sir.
All right, the court in this cause number 241-0118-21 does formally pronounce sentence. The court finds the defendant guilty of the offense alleged in the indictment, follows the plea agreement, assesses the sentence in the case, which will be reflected, of course, on the judgment of the court at 32 years of the Texas Department of Corrections Institutional Division. That 32-year sentence is assessed with time credit for time served, which the plea papers indicates November the 27th, 2020 to the present. Lab fee of $180 is assessed, and court has already said and announced a couple of times. So at 12:45, the court has considered Mr. Gerald 241011921 and 2410120-21. Those have been taken into consideration under 12:45 on the 32-year sentence. So those will be dismissed. Waiver of appeal, waiver of right to file motion to trials, all accepted and approved. Mr. Carew, you'll be continued to the custody of the sheriff until you can be transported to a unit of the Texas Department of Corrections Institutional Division to serve the 32-year sentence assessed by the court with credit for time served. Anything else, Mr. Gerald?
No, Your Honor.
Anything else, Mr. Robeson?
No, Your Honor.
All right, do you understand all this, Mr. Carew?
Yes, sir.
All right, we're in recess, counsel. Thank you. Oh, Mr. Carew?
Yes, sir.
I got one other question. I think I may have missed, I may have asked you, but I want to be sure. Are you satisfied with the legal representation of your court-appointed attorney, Mr. Robeson?
Yes, sir.
Okay, I just want to make sure. We're in recess.
Tabitha, we're going downtown.
Yes, we are. Sir, what is your name?
Dominic Davis.
Okay, thanks.
All right, it's like by Zoom. We're on the record, and I don't believe I've got a state's attorney yet.
Here, Judge.
All right, Ms. Anderson's on now. We're on the record in cause number 241-1403-20. State versus Dominic Davis. He's present before the court by Zoom from jail. And Mr. Roberson, his attorney, is present before the court by Zoom. Ms. Anderson is present before the court by Zoom, Assistant District Attorney. Apparently, looking at the file, we must just be here for announcements.
That is correct, Your Honor. It's set for a plea on the plea docket. However, my client informed me last week that he wants a trial, Your Honor.
And Your Honor, so my offer originally was 5 years TDC in this case. We haven't really done any negotiation. It's my understanding that Mr. Davis had another felony case pending in Henderson County, and he had been at the Henderson County jail. My offer was supposed to have been extended to him in Henderson County to be a global offer and resolve all the cases together. And so Mr. Roberson and I may need to talk about this and find out. I don't know how the Henderson County case resolved. I'm not sure where things stand. So even though they're announcing jury trial today, I'd like to ask Mr. Roberson and the court if we could have a little more time to discuss this.
Okay, this indictment, just for the record, has a $25,000 surety bond on it. Was he adjudicated and assessed a sentence in Henderson County, Mr. Roberson?
I'm not sure, Your Honor. I can Zoom with him, get back with him, and get back with Mr. Anderson. If you could just reset this case. I think I have a docket next week, which is on the 10th.
All right.
And I'm sorry, Your Honor, I don't think Mr. Roberson and I didn't realize that Mr. Davis, I didn't know when he was returned to Smith County. And so I think maybe we've had some miscommunication and perhaps if we negotiate a little bit more, we may be able to come to some agreement.
Well, hopefully so. So you don't really have the paperwork yet from Henderson County to be sure what happened over. You didn't represent him over there, Mr. Roberson, is that right?
That is correct, Your Honor. And if we could just reset this, Tabitha, do we have a docket for next week?
Yes, you sure do, on the 10th at 9:30.
Okay, Elizabeth, would that give you enough time and I can get in touch with Henderson County and my client?
Yes, and I'm sorry, Clifton, I just didn't notice this until right this minute, or I'd have alerted you sooner. So we just miscommunicated, but I think between the two of us, we could probably figure out what happened.
Well, if
Okay.
he's already been adjudicated over there in Henderson County, I'm sure he knows, but I don't want to
Yes.
ask him that now.
Everything's
If he
done.
has been, I mean, if he's already got a sentence over there, then that puts y'all in a position to consider that sentence with whatever the recommendation is going to be here to see if, you can get them both wound up.
Yes, Your Honor. And I get with him and it's on the docket for next week, Your Honor, on November 10th.
All right, then the defendant's continued in custody. Bond on this indictment is $25,000. I don't know what he got over in Henderson County. Maybe already.
Everything's finished over there.
What? Say it again.
Said everything's finished over there.
What's your sentence?
Everything time served
Okay, so.
on August the 9th.
Okay, well, that tells me one thing I need to know. So Mr. Roberson will get with you. I'm resetting it for a plea. What was it, the 10th next week, on the 10th?
Yes, Your Honor.
But do we have a time on that, Tabitha?
9:30.
9:30 next Wednesday, the 10th. We'll be back on Zoom, figure out what we're gonna do. All right, defendants continued in custody. Unless there's anything further, counsel, we're in recess. And Mr. Roberson, you'll get with Mr. Davis, correct?
That is correct, Your Honor.
All right, we're in recess. Defendants continued in custody.
Thank you, Your Honor.
Thank you.
Tabitha.
Let them know that we need Gilbert Garcia next.
Judge, Mr. Garcia is one of Mr. Drawls, so we'll get him back on here.
Okay.
I'm here.
Be careful on that thing. Yeah, golly Moses, that's a balancing act with a bat. Be careful going backwards. Damn, let me come out there and get these. You don't have to bring these damn files in here. I can come out there and get them. Good grief. All right, we're on the record by Zoom and calls number 24109-19-21 State versus Gilbert Garcia. Gilbert Garcia is present before the court. He's in custody on an indictment charging the offense of aggravated robbery, a first-degree felony, of course, alleging the use of a deadly weapon, a firearm. The bond on the back of that indictment is $150,000 surety bond. So the defendant is present by, Mr. Garcia is present by Zoom. His attorney, Mr. Roberson, is present by Zoom. Is that, well, Ms. Anderson, state's attorney, is present by Zoom also?
I'm the state's attorney for this one, Judge.
Okay, I'm not trying to take it away from you. I was working my way up to you. Mr. Gerald, like I was going to say, we actually have two state's attorneys on, but we have one on this case, Mr. Gerald.
Yes,
So
sir.
what do we got here, Mr. Gerald?
Your Honor, this is a ag robbery case. I believe that Mr. Roberson and I have discussed it, and I think Mr. Roberson told me that Mr. Garcia is trying to hire outside counsel.
Judge, that is true. Mr. Gilbert Garcia has an aggravated robbery case and a UCW felon, possession of firearm by a felon. I discussed the case with him, also the plea offer via Zoom last week. He informed me that he was going to hire an attorney, Your Honor.
Well, let's see, the bond on the indictment's $150,000 surety bond. He's in custody. He's continued in custody on the indictment with $150,000 surety bond. I mean, I need to check and see when this is set, Mr. Gerald. I mean, we'll have to get the case moving.
Yes, sir.
Does anyone know offhand what setting we have on this yet, if any?
All I know is on the plea docket for today, Judge, and he said he's going to hire an attorney. If we can give him, I guess, a couple of weeks and see if he's going to hire the attorney and put it on a status docket in 2 weeks, Judge.
Your Honor, if I may, he's got a co-defendant that is set, I think, for that'd be Samuel Garcia. I think he's set in a couple of weeks as well. So set it about then if the court could allow that.
Okay, Tabitha, if you're listening out there, we need to set this case. Well, I'm sorry, Mr. Draw, what date did you say we probably should set it on when the co-defendant set?
I think it's the 15th, Judge. Let me look at my calendar right quick.
Okay,
I have a date of the next time Clifton will be in our office, of December 1st, if we want to set it for a status hearing.
is December 1st all right, Mr. Draw?
December 1st works for me, Your Honor. I'd rather get it done sooner rather than later. Samuel Garcia is set on the 15th for the.
Let's put this one on December the 1st because the court and state and defense counsel, obviously, we all need to know whether or not Mr. Garcia is going to be able to hire an attorney. He has a good court-appointed attorney now, but he has the right to hire his own attorney. But I can't, just piddle around with the case waiting for him to hire an attorney. It might become evidence that he can't afford to hire an attorney. Right now, he has signed an indigency affidavit, and that's why I appointed Mr. Roberson. So we'll set it. Was it December 1st, Mr. Draw? Is that what you suggested?
Yes, sir, that's correct.
All right, the court, is that agreeable with you, Mr. Roberson?
It is, Your Honor.
All right, defendant is continued in custody on this indictment with the current bond set, and the case is now set before the court on December the 1st. Did we have a time on that?
9:30.
Okay, Tabitha, he'll be back on with us on Zoom on December the 1st. I'm sorry, Tabitha, what day of the week's that?
Wednesday.
Wednesday, December the 1st at 9 o'clock. Defendant will be back on Zoom with his counsel, Mr. Roberson, and also Mr. Gerald. You need to understand, Mr. Garcia, that the case is working its way towards the trial docket. And you certainly have every right to hire your own attorney, but the court can't get into a situation where you're just sitting over there in jail, saying you're going to hire an attorney. I'll reach a point where if you don't have an attorney hire, I'll have to go forward with a court-appointed attorney. You understand that?
Yes, I understand that, but if I get one, I need one that's gonna help me represent himself as a professional, not wait about a month and a half later and come and see me. When he's by law, it says 3 days, 72 hours. He's got to come and let me know. I didn't even know what his name was or none until just recently.
Well, now you know, and I can tell you, Mr. Garcia, you're the hundreds of people in defendants in these jails. And I don't know, I don't have a count. I don't have any way of knowing how many times a court-appointed attorney can get over and see a defendant within 3 days. I would say that's unusual because of the numbers. There's 3 court-appointed attorneys in this court, 3 in every district court. And so that may be what it says on paper, but that's unusual for them to be able to get over. They've got other attorneys going. I mean, they've got other cases where they're representing the defendants as attorneys going to trial. So if I were you, it's up to you. But at any rate, we're set now for the date I put in the record, and we'll be back on Zoom by that date to determine whether or not you've been able to hire your own attorney. If you haven't hired your own attorney, I'll set it for trial. Anything else, counsel?
No, Your Honor.
No, Your Honor.
All right, we're in recess, counsel. Defendants continued in custody on the $150,000 surety bond on the indictment charging the first-degree felony aggravated robbery as charged in the indictment. We're in recess till December 1st.
Your Honor, I believe that's my last case. May I be excused?
Yes, thanks, Mr. Draw.
Hey, Clifton.
Yes.
I just looked at Mr. Garcia's file. I'll be Brooksing. I just texted you as well. I'm going to be Brooksing a prior that I didn't know about until just now.
Okay, and I'll get with him and see if he can hire an attorney.
All right, thanks.
You're welcome. Mr. Garcia, will you tell me we need Mr. Anthony Sherfield?
Yes, sir. Thank you.
You're welcome. Anthony, we're gonna get started here in 3 minutes with the judge. The prosecuting attorney said he wouldn't do the 5. He's gonna stick with the 7. Do you still want to do that? Can you hear me?
Yeah, I can hear you. If I don't do that, then it just make
Yeah,
it worse.
you have to go over to the judge.
It just make it worse. So I mean, I ain't got no choice.
Okay. All right, the judge will be with you in a few minutes then.
All right.
All right, we're on the record by Zoom in calls number 241-1565-20. State versus Anthony Sheffield, who's present before the court by Zoom from jail. His attorney, Mr. Robertson, is present before the court by Zoom. Ms. Anderson, state's attorney, is present by Zoom. This is on the state's motion to adjudicate guilt. The court takes judicial notice of all the prior proceedings and the contents of the file. You want to waive the reading of the state's motion to adjudicate guilt, Mr. Robertson?
Judge, we waive the formal reading of the state's motion to adjudicate guilt. His name is correctly set forth in the motion. He knows what the allegations are, Judge. He's going to enter a plea of true. And Judge, I think the paperwork says there's a recommendation of 5 years. However, it's supposed to be 7 years, Your Honor, instead of 5 years.
All right, Mr. Sheffield, just raise your right hand so I can get you sworn in. Do you solemnly swear the testimony you'll give before the court will be the truth, the whole truth, and nothing but the truth, and that all the plea documents which show to be not only signed by you, but are sworn to by you, are sworn to by you now under oath, freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right. There you go. Be sure to speak up, Mr. Sheffield. You got a mask on. I've got to be able to that's fine, but I've got to be able to hear you.
Yes, sir.
Have you been over the state's motion to adjudicate guilt with your attorney, Mr. Robertson, so you understand all the allegations being made against you in the state's motion to adjudicate guilt, which all allege violations of your deferred adjudicated probation?
Yes, sir.
All right, now I've got a document that's up there on the screen already that I need to go over with you. First of all, that's signed by Mr. Robertson down the right side, down the left side. There's a signature, Anthony S. Is that your signature, Mr. Sheffield?
Yes, sir.
All right, when you look at that document up on the screen, the written plea admonishments and stipulations of evidence, obviously the original indictment, the indictment charging enticing a child away from a custodian. The maximum sentence is a third-degree felony, up to 10 years in TDC, fine of up to $10,000. You're appearing before the court with your attorney, court-appointed Mr. Clifton Roberson. There's 4 admonishments, just a big word for explanations. Do you understand all 4 of those explanations, 1, 2, 3, and 4?
Yes, sir.
The next portion of the paragraph, I'll just read it to you. It simply says, acknowledging the foregoing, the defendant and his attorney state that you fully understand and have read the foregoing admonishments 1 through 4, as well as the allegations being made against you as set out in the state's application. Now, that state's application is the state's motion to adjudicate guilt. I placed you on deferred adjudicated probation. Now the state's filed this motion to adjudicate your guilt. Adjudicate, just a big legal word, meaning the state's alleging in this motion you have violated the terms and conditions as set out in this motion. And if you plead true to those allegations, or the state proves them to the court, I would grant the state's motion to adjudicate. That word means the court would then just go back and find you guilty of the offense of enticing a child away from a custodian with the intent to commit a felony, third-degree felony, and then because you're on deferred, you could receive up to the maximum. Do you understand all that?
Yes, sir.
Now, the document here, going back to it, that's in front of us, the written plea admonishes stipulation of evidence. You signed it. You're sworn to it. It's signed by Mr. Roberson. And you tell me down here that you, the person whose signature appears down here below, Anthony Sheffield, and is the same person who obviously was placed on deferred adjudicated probation by the court in this cause number. And then under 2, this is what you say. You say that all the allegations is set out in all the paragraphs of the state's motion to adjudicate guilt. And those are allegations that allege violations of your deferred adjudicated probation. You say all those allegations are true and that you, with your attorney present, enter pleas of true to all the allegations in the state's motion to adjudicate guilt, which all allege violations of your deferred adjudicated probation. Do you understand that?
Yes, sir.
Are you stipulating in any of those pleas of true to these allegations that you violated your deferred adjudicated probation freely, intelligently, knowingly, and voluntarily? In other words, are you pleading true to those allegations alleging violations freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, the court does receive and accept your pleas of true, and the court does find those allegations as set out in the state's motion to adjudicate to be true. The court does, Ms. Anderson, you offering 5 in?
No, sir, it's 7.
No, the exhibit.
Oh, am I offering 5?
Okay.
Yes,
So
I'm offering states 5 and the agreement is 7 years. Thank you, Mr.
all right,
Robertson.
I'm with you. All right, Mr. Roberson, you don't have any objection to states 5, correct?
No objection, Your Honor.
States 5, the written plea admonished stipulations of evidence submitted into evidence with no objection. The court having admitted in states 5, which is the written plea admonishes stipulations of evidence which contains the defendant stipulated and entered pleas of true to all the allegations in the state's motion to adjudicate guilt, which allege violations of his deferred adjudicated probation. The court finding his pleas of true were entered freely, intelligently, knowingly, and voluntarily. The court does grant the state's motion to adjudicate guilt. The court does find the defendant guilty of the offense alleged against him by the state in its indictment, enticing a child away from custodian with intent to commit a felony, third-degree felony as alleged in the indictment. The court having received and accepted the defendant's pleas of true, granted the state's motion to adjudicate guilt. Having found the defendant guilty of the offense alleged in the indictment, moves to sentencing. Ms. Anderson.
We have an agreement for 7 years confinement in the institutional division.
7 to do with credit, Mr. Robertson.
That is correct, Judge. We're requesting the court follow the recommendation, Your Honor.
All right, the court in this case having granted the state's motion to adjudicate guilt, the court having found and does find the defendant guilty of the offense alleged in the indictment, the court follows the plea agreement recommendation of state, sets the sentence at 7 years in the Texas Department of Corrections Institutional Division for the offense alleged in the indictment. 7-year sentence is assessed with the court following the agreement, and the 7-year sentence is assessed with credit for time served. Any legal reason bar formal sentencing?
No, Your Honor.
Finding none, the court formally pronounces the sentence. The court does find the defendant guilty of the offense alleged against him by the state in the indictment, enticing a child away from a custodian with intent to commit a felony, and the court follows the plea agreement. The recommendation of state assessed the sentence 7 years in the Texas Department of Corrections Institutional Division. That's assessed with credit for time served. Sentence is formally pronounced. Mr. Sheffield, do you understand you earlier filed with the court a waiver giving up your right to appeal? Are you now presenting that waiver giving up your right to appeal from these proceedings today to the court?
Your Honor, I don't understand.
Okay, well, I'm sorry. What do you not understand?
I don't understand like what you
Okay,
I don't understand.
I say it so much, sometimes I may say it a little fast. I have granted the state's motion to adjudicate. That means I've gone back and I've found you guilty of the offense charged in the indictment, enticing a child away from a custodian with intent to commit a felony. Now, I found you guilty because I granted the state's motion to adjudicate guilt based on your pleas of true, written, and entered. So then I moved to sentencing, and I have a plea agreement between you, Mr. Roberson, and the state that I would assess the sentence at 7 years in the Texas Department of Corrections Institutional Division. The maximum is 10. That I would assess the sentence at 7 years in the Texas Department of Corrections Institutional Division with credit for time served, and that's what I just did. So I've sentenced you following the agreement between your attorney and the state's attorney and you, that your sentence is assessed at 7 years in TDC, Texas Department of Correction. It is assessed with credit for time served.
What does the excess with time served mean?
What it means is you will get credit on that 7-year sentence in the Texas Department of Corrections for all the days you spent in the Smith County Jail.
Okay, thank you. Yes, sir.
That's what it'll mean. That's the way the sentence is, pronounced. Also, Mr. Sheffield, I have from you a waiver signed by you and Mr. Roberson. It's a waiver. When I say waiver, meaning it's waiver of your motion for new trial, and it's a waiver of your right to file a notice of appeal. So what waiver means giving up. So do you understand you're giving up your
Yes,
right to file a motion for new trial? You're giving up your right to appeal. You understand all that?
Yes, sir.
All right, it'll be the order of the court then, Mr. Sheffield. You'll be continued to the custody of the sheriff until you can be transported to the Texas Department of Corrections Institutional Division to serve the 7-year sentence assessed by the court
Okay. Yes,
for the
sir.
offense charged in the indictment. And that 7-year sentence assessed by agreement of state and defense is assessed with credit for all the days you served in the Smith County Jail. Waiver of appeals accepted. You understand all that, Mr. Sheffield?
Yes, sir.
Anything else, Mr. Roberson? Oh,
Just one thing, Mr. Sheriff's Alexia, and all the paperwork was read to him. I read the application to revoke to him because he has a problem understanding or reading because of his dyslexia, and also the stipulation that was presented to the court was read to him also, Judge, before he signed the paperwork.
All right, so Mr. Sheffield, you did understand the state's motion to adjudicate, big word, meaning that's the motion where the state makes its allegations against you for violations of your deferred adjudicated probation. Do you understand that?
Yes, sir.
And then what takes place in the written plea admonishments or stipulations of evidence, which has been admitted into evidence, states 5. It's been up on the screen, but this, you signed it and sworn to it. And this is what you said, going through the plea. You said that the allegations as set out in all the paragraphs of the state's motion to adjudicate guilt, those allegations allege violations of your deferred adjudicated probation. And you stated in your paperwork and on Zoom that the allegations in all those paragraphs which allege violations of your deferred adjudicated probation are true. Do you understand that?
Yes, sir.
All right, and because you pled true, to those allegations, and I found you pled to those allegations freely, intelligently, knowingly, and voluntarily, and still do. I granted the state's motion to adjudicate your guilt. Adjudicate's just a big legal word, meaning I then go back and find you guilty of the offense charged in the indictment, which I've done, and then I followed the plea agreement recommended by the state and agreed to by you and Mr. Robertson, and I've sentenced you to 7 years in the Texas Department of Corrections Institutional Division, and I've given you credit for time served for your time in the Smith County Jail. You'll get credit on that time for the 7-year sentence in the Texas Department of Corrections Institutional Division. Do you understand all this, Mr. Sheffield?
Yes, sir. I don't know exactly how many months I got it combined.
You don't have to worry about it. I would probably worry about it because you've been the one sitting there, but that will be sent to the Texas Department of Corrections Institutional Division by the Smith County Jail. So when you book into TDC after you're transported down there, Texas Department of Corrections Institutional Division, the intake officer will look at the number of days you've been in the Smith County Jail. You don't actually have to know what they are. You can ask the jail and they'll tell you. They'll send that number of days to TDC. So
Okay.
on your 7-year sentence, that's what we've been talking about. You'll get credit for that number of days you've been in the Smith County Jail. In TDC, TDC will see it on your paperwork. You don't have to know exactly how many it is. If you ask the jail, they'll tell you.
Yes, sir.
All right, and you are satisfied with Mr. Roberson's legal representation. I probably asked you that 2 or 3 times, but I have to be sure.
Yes, sir.
All right, anything else, Ms. Anderson?
No, Your Honor.
Anything else, Mr. Roberson?
No, Your Honor.
All right, the defendant, Mr. Sheffield, continue the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the 7-year sentence assessed by the court for the offense charged in the indictment with credit for time served in the Smith County Jail. We're in recess.
Will you let them know we need Tanya, please?
Say, Mr. Roberson, can you, he's on his way somewhere else. I don't blame him.
That's okay.
We need, I got it, tablet. We need Tanya Somerville. Can someone let them know?
That's all right.
Oh, I think she's sitting there. Tanya Somerville, what's she doing? State jail felony. Yeah, let's see. We need Tanya Somerville. Tanya Somerville. Can you hear us?
You need Miss Summerfield?
Yes, sir. Thank you.
Yes, sir. Hang on just one second.
There she is, Your Honor.
Got her now. We're on the record in cause number 2410445-20. State versus Tanya Somerville. She's on Zoom before the court with her attorney, Mr. Roberson. Ms. Anderson is present for the state. On indictment charging unauthorized use of a motor vehicle, state jail felony is alleged in the indictment. Going to waive the written presentation of the indictment, all the other formalities, Mr. Roberson.
Judge, the way the form reading of the indictment, her name is correctly set forth in the indictment. She knows the range of punishment, what she's charged with. She's going to change her plea from not guilty to guilty, Your Honor.
Ms. Somerville, can you hear me?
Yes, sir.
Okay, raise your right hand to have to swear you in. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Ms. Somerville, the indictment's up on the screen in front of you. You can look there and see it. Do you understand all the allegations and the charge in the indictment against you for unauthorized use of a motor vehicle?
Yes, sir.
Do you understand that state jail felony carries a sentencing range of not less than 6 months to more than 2 years, and state jail sadly fine of up to $10,000. You have a plea agreement, you and Mr. Roberson and Ms. Anderson, if you enter a plea of guilty to the indictment. Ms. Anderson is going to recommend your sentence at 9 months in a state jail facility. I'm going to follow that recommendation, sets the sentence at 9 months. In addition, the court will give you time credit or credit for time served, which is written on the plea papers by Mr. Roberson, which is all I know about it. It says 4/10/21 to 8/6/21, looks like in Alabama, I suppose. And then 8/6/21 to the present in the Smith County Jail. So you'll get credit on your 9-month sentence for from all those days you spent in Alabama and you spent in the Smith County Jail. And then your plea is for 9 months with credit. Is that your plea agreement, Ms. Somerville?
Yes, sir.
Is that it, Ms. Robertson?
That's correct, Your Honor.
That's your recommendation, Ms. Anderson?
It is, Your Honor.
All right, now, Ms. Somerville, have you got all these plea documents? Easy one to look at. Just look at the one on the screen down the rounds. Of course, they're signed by Ms. Anderson, Mr. Robertson. On the line above says defendant. That's signed Tanya Somerville. That signature was on all the plea papers. So is that your signature?
Yes, sir.
Now, some of these plea documents need to be sure I get you sworn in, but if I haven't already, did I get her sworn in, Ms. Anderson or Mr. Roberson?
She said you sworn in, Your Honor.
You understand you're under oath, Ms. Somerville?
Yes, sir, I do.
All right, so start off 9 months with credit for time served, which is written there on the plea papers. You can see it at the top. So that's your plea agreement.
Yes, sir.
All right, the second plea document just gives you the full range of sentencing, not less than 108 days, more than 2 years of state jail facility. Your sentence will be what's recommended. Total of 5 admonishments are just explanations. Your signatures, Mr. Roberson's, are below the 5th one. You understand?
Yes, sir.
You understand those?
Yes, sir, I do.
You understand you're waiving giving up your right to a trial by jury on this indictment. You understand that?
Yes, sir.
Your next document, you waive confronting witnesses on the plea and agree to stipulate testimony. The stipulation of evidence is in the next document, signed and now sworn to by you. That's a written judicial confession or admission under oath by you, signed by you and Mr. Robeson. You're admitting all the allegations and the charge in the indictment. You understand that?
Yes, sir.
And you did sign this stipulation of evidence freely, intelligently, knowingly, and voluntarily. Is that correct?
Yes, sir.
Then you've agreed to stipulate testimony. You understand you've waived giving up your right to appeal and waived giving up your right to file a motion for new trial. You understand all that?
Yes, sir.
Okay, you have any questions for me about anything? I'm just going to go through and ask you some pretty simple questions.
No, sir, I don't.
All right. First of all, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours in jail?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, toxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined to a mental institution or under psychiatric treatment?
No, sir.
You understand everything you're doing in court today?
Yes, sir, I do.
Have you gone over everything about your facts of your case and all these plea documents you've signed and all you've done in court today with your attorney, Mr. Roberson?
Yes, sir, I have.
Is she confident, Mr. Roberson?
Yes, Your Honor.
Yes, been confident, Mr. Anderson.
No, sir.
All right, court notes states counsel sign her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. Court also approves all the other waivers and plea documents in the case, signed sworn to by the defendant, signed by her attorney. All right, now, Ms. Somerville, you do understand all the allegations and the charge in the indictment against you for unauthorized use of a motor vehicle, correct?
Yes, sir.
You understand the full range of sentencing for a state jail felony and all your plea papers, including your plea agreement, which is 9 months in a state jail facility with credit for time served. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir, I don't.
In cause number 2410445-20, what is your plea today to the indictment? Charging you with unauthorized use of a motor vehicle, a state jail felony. Like, is your plea guilty or not? Guilty?
Yes, sir.
I'm sorry?
Guilty, yeah.
All right, are you entering your plea of guilty to the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or make you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed this offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment because you have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment. What do you have, Ms. Anderson?
Your Honor, we offer states 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
No objection. States exhibits 1, 2, and 3 are admitted into evidence. The court finding of the defendant's waiver of rights, execution of all the other plea documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. The court receives and accepts the defendant's plea of guilty to the indictment, and the court finds the defendant guilty of the offense of unauthorized use of a motor vehicle, state jail felony as alleged in the indictment. Moving to sentencing.
The offer states for an electronic copy of a digital copy of the written discovery in this case.
No objection, Your Honor.
Stage 4 is admitted into evidence, all the discovery in the case with no objection. Anything else for sentencing on the plea agreement, Mr. Robertson?
No, Your Honor.
Court in the case then, based upon the defendant's plea of guilty to the offense of unauthorized use of motor vehicle, state jail felony as alleged in the indictment, and the evidence approved, presented by the court, and admitted into evidence by the court. The court does find the defendant guilty of the offense alleged in the indictment, unauthorized use of motor vehicle, state jail felony. Court follows the plea agreement, assesses the sentence at 9 months in a state jail facility. The court formally pronounces sentence, finding the defendant guilty of the offense of unauthorized use of motor vehicle, formally pronounces sentence at 9 months in a state jail facility. The court assesses sentence at 9 months with credit for time served. Now, Ms. Somerville, according to what Mr. Roberson's written here, he's usually right, and it says you're getting credit for time from April the 10th, 2021 to August the 6th, 2021 in Alabama. And then you're getting credit from August the 6th, 2021 to the present in the Smith County Jail. So your 9-month sentence is assessed with all that credit. Now, that credit has to be verified by the jail and by the state jail facility you're going to, then you'll get the credit. You understand that, Ms. Somerville?
Yes, sir.
Are you satisfied with your court-appointed attorney, Mr. Clifton Robertson?
Yes, sir.
Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Robertson?
No, Your Honor.
All right, we're in recess. Defendant's continuing in custody until she can be transported to a state jail facility, serve a 9-month sentence assessed by the court with credit for time served. We're in recess.
Thank you.
Judge, I think that's all the cases I have before the court. Can I leave?
Well, yes, you can, because I have no legal reason to keep you here.
Well, thank you, Your Honor.
I
I'm
don't
gonna go
think-
ahead
I
and
can think
elevate
of
the
couple-
case like the doctor told me to
I
do.
think a couple of matters we could discuss, but I guess we'll wait till you're by the office.
I should, the judge, he's gonna release me on November the 18th and I'll come by the office.
November the 18th.
Oh, November 18th. So you won't be able to try any cases on the 15th.
Well, I can. I'm on a walker. I think he takes me off the walker on November the 8th.
We're not going to do that to you, Clifton. Let's give you time to heal right, because then we can, run you ragged next year.
Hold on. Let me straighten this out. Here's what I want to make sure of.